$84 trillion is set to change hands over the next 20 years. Whether you're passing it down or inheriting it, the decisions you make today will shape your family's financial future for generations. Welcome to the Great Wealth Transfer, where David Pulcini, CFP, guides you through the strategies, insights, and pitfalls of navigating one of the largest financial shifts in history. What you don't know could redefine your legacy.
Unexpressed expectations are premeditated resentments. So I'm going to say that again in a minute, but that one packs a punch, and it's a great quote to set up the idea that silence, vagueness, or assumptions in estate planning can create emotional chaos down the line. So think about that again. Unexpressed expectations are premeditated resentments. And that can apply to many parts of someone's life. It could be relationships, business, but we are here to talk about estate planning. And today we're going to dive into one of the most emotionally layered and logistically complex estate planning scenarios out there, and that is blended families. Okay, so whether you've remarried, you have stepchildren, you're navigating second or third partnerships, your estate plan needs to reflect that and reflect the full, now nuanced story of the family, right? So if you don't plan carefully, you risk not just legal disputes, but strained relationships, unintended tax consequences, and fractured legacies. And fractured legacy, I want to say that's an interesting term. And when it comes to this type of planning, the estate planning, the real danger isn't just taxes or probate. It's something far more personal. And I want to say that fractured legacy again. That's what happens when good intentions are buried beneath vague documents, outdated beneficiaries, or again, those unspoken expectations. So there's something about those words. There is something about those words, fractured, that to me make me want to get this stuff done. It would really motivate me. You work, you accumulate, you do the right things, and when you are gone, simply the way that you leave your stuff can fracture the relationships, and nobody wants that. So, and the thing is, it's almost always avoidable. And with the right conversations and planning, your legacy can actually unify your family, even when the family tree has an extra few branches, right? Like in the blended families that we're talking about today. So how do we reduce the risk of this happening, that fracturing? We're going to break that down. We're going to break down what can go wrong, what documents you need, and how to build a plan that truly honors your intentions. And to bring it to life, I'll share some cautionary tales, real life examples. We can use celebrities that had this and they had the means, but they missed the mark, right? So a quick stat here that is, I think it's kind of unbelievable, but if you think about it, it is most likely true. 40% of married couples with kids in the U.S. are now part of a blended family. That is a massive portion of the population navigating estate issues that weren't even on the radar 50 years ago. And I'll say this, yet most estate plans, they are still built for that traditional nuclear family. So if this isn't you, and you are that traditional nuclear family, you probably know someone. Maybe it's your adult children, a sibling, a colleague. You certainly know someone who this applies to, right? If you think about it. So blended families do introduce all sorts of tough questions that people don't like to answer, but we should answer them. And I'll give you some examples. So do you want your spouse to inherit everything, even if they are not the parent of your kids? Think about that. What if your spouse remarries or begins a relationship when you're gone? We're going to go into detail on that. What if your kids are still minors and your new partner becomes their step-parent? Or how do you ensure fairness when one child from your first marriage and another child is shared with your current spouse? Okay? The answer to all this is planning early, planning intentionally, and documenting everything with absolute clarity. So let's do some real stories here. And I'll start with a true, I'll call him a Hollywood legend, right? Everybody knows Robin Williams. And for the record, I don't like these examples of people that did not plan properly. These are real people with real families. The families are left behind, and something does not feel right about using their perceived failure as an example of what not to do. But the truth is, these examples are actually very relatable, and people pay attention when a celebrity name is involved. So back to Robin Williams. He had 3 children from a previous relationship and was married to his third wife when he passed away, Susan. He actually did what many would call responsible planning. He set up a trust. He provided for his wife, Susan, and left the remainder to his kids. But that is where folks would say it unraveled. The trust did not clearly define what counted as personal belongings. So when Robin passed away, it said that his wife, Susan, and the kids fought over things like clothing, watches, his awards. His Academy Award tuxedo became a point of legal contention, right? And that it's not the millions of dollars in cash, but the sentimental items that created that friction. So the issue here was the plan was not detailed enough, and the expectations, going back to that, were not aligned. And the emotional toll and legal fees could have been avoided, okay? Another example, Aretha Franklin. This is a really interesting one. She had multiple handwritten wills, and none of which were actually witnessed or properly witnessed. So when you do a will, it should be witnessed by somebody, and they sign off saying that they saw you sign the will. After her death, her sons ended up in court fighting over which document was actually legitimate. And it took years to settle, and it cost millions and millions of dollars. And obviously it was a legal battle. If you just search the internet, you'll see things like, quote, Aretha Franklin's sons are awarded property thanks to a will found in the couch. It's real. And how $80 million turned into $6 million. And I can't validate if that's true or not, but it certainly could be, right? $74 million in legal fees and losses and probate costs. And we found the will in the couch. That sounds crazy, but that's real. And how about a recent one with Gene Hackman? So Gene had multiple marriages, children from different relationships, and according to the recent records, he had one beneficiary, which was his wife, who unfortunately passed away nearly at the same time, according to the law, right? Gene's children, who were not in the will, could now contest it. His beneficiary was his wife. We are not to judge whether he wanted that or not, but that was his only beneficiary. Now the kids, maybe he intentionally left them out, maybe he didn't, can now contest it because wife passed away at the same time, and he had no successors in there or contingent beneficiaries. And this will probably most likely drag out in court, rack up expensive legal fees, and who knows how the estate taxes will be handled on an $80 million estate, okay? And actually, let me give you another one. Speaking of that, that brings to mind one more. James Gandolfini, Tony Soprano himself, right? He left his family $70 million, but it was not structured properly. And over $30 million of that went to estate taxes that could have easily been avoided with trusts or lifetime gifting strategies. And I know many of you are saying, yeah, big deal. They only get $40 million now, but trust me, no one wants to leave $30 million to the government. I'm sure if he had to give that away, think of the good that he could have done for a cause that he actually cared about rather than giving it to the good old government, right? $30 million is a lot of money to give away. So I could keep going with celebrities, but I'm going to stop there. And I'll just say this, even the rich and famous get this estate planning stuff wrong. I could give an entire list of folks that have not done this right. And we often just say, hey, how did this happen? Why? They're extremely wealthy. What's going on? I'd say it's a few parts. One of them is the emotional complexity of the family might be very hard to plan for. There's a lack of updating as things change. These people are usually busy, as you are. And as things change, these things should be updated. It also takes a little bit of time that people don't think they have. So one suggestion here, an action item, is just put it in the calendar. Review. I've said this many times before. I'm making this up. Put it in July 1st. Do I need to update my estate plan? Put the attorney's email right in that calendar entry. And if you have to do anything, click their email and say, hey, I need to do an update. Okay? So let's pivot to solutions here. And here's what we believe blended families must have in place. And number one is a will, and it should be crystal clear. So try to use names with a blended family, not terms like my children, because in blended families, you might have different children from different relationships. And then whose children are we talking about? Let's use names. Be specific about personal belongings or effects, just like Robin Williams should have been, right? Number two, revocable living trust. This is the control mechanism. You can say, hey, my spouse gets income for life. My children get the principal after my spouse passes. If my spouse remarries, certain assets go back into a trust. And some of these rules are great, by the way. Actually, I'm going to go on a tangent here. Let's say the surviving spouse gets remarried. So think about that. Think of this. You've built a beautiful lake house, custom cabinets, perfect view. All the little details are just right. When you're gone, you want your spouse to enjoy that lake house, maybe host the kids, the grandkids. You want them to sit on the porch with a cup of coffee and think of you. But here's the thing. Carl, let's name him Carl. You didn't build that house so that your spouse's next spouse could roll in wearing his terrible boat shoes, claim a spot in your recliner, and start calling your grandkids buddy. Okay? That's where trust comes in. You can set it up so that your spouse has full use of that lake house, lives in it, enjoys the income from it. But if they remarry or pass away, the property goes back into your family trust. That way, the house or investment accounts or family business ultimately lands with your kids, not in the hands of someone who was not part of the original plan. So, and by the way, that's how you support or provide support and structure at the same time, okay? Beneficiary designations. I want to remind everybody of this. Remember, your IRA, your 401k, your life insurance do not follow the will. They go to whomever is named on the form, whether that's your current spouse or your ex from 15 years ago. Okay? Make sure those are updated. Power of attorney and healthcare proxy. Who steps in if you're incapacitated? Your adult child? Your new spouse? Choose now and put it in writing. Okay? I'll say this, estate planning without tax planning, okay? Two different things, but they go hand in hand. It's like building a house without a roof. It might look good until it starts to rain, right? Let's talk about some solutions here. A QTIP trust, literally QTIP, technical, qualified terminable interest property trust, gives your surviving spouse that income for life while preserving your principal for your children. It qualifies for the marital deduction, and that can reduce your estate tax exposure. I want to go back to my example of the guy sitting in your chair and calling your grandkids buddy, because my thought would be, well, if I'm that guy, if I'm Carl, I just won't get married. And this is where things even get trickier, right? A lot of people focus their estate plans on what happens if the surviving spouse remarries, but they forget that remarriage is just one way of moving on, right? There are many flavors of that. And today, long-term partnerships without marriage are more common than ever, okay? And financially, they can have very similar implications, okay? Let's say the surviving spouse doesn't remarry, but just starts dating someone new. They're not walking down the aisle, but they're sharing life, vacations, finances maybe, and suddenly the wealth that you built is being enjoyed by Carl, who's now riding shotgun in your car or driving it or spending time in your condo, using your treadmill, taking up your closet space. So I'm laughing, but this stuff happens. No legal marriage, no prenup, just Carl, slowly or maybe quickly blending into the picture, right? If your estate plan doesn't specify protections, Carl is going to directly benefit from your legacy, and your kids might be left wondering, why is my inheritance going to this guy because of some retirement romance? A properly structured trust can ensure that your assets support your spouse and only your spouse without opening the door for, we'll call it plus ones to enjoy the ride, right? So here's where this type of trust can get specific. You can include remarriage clauses, but you can also go further by defining what constitutes a non-marital partner relationship. So essentially saying, if my surviving spouse cohabitates with someone for more than X months or merges finances in a certain way, their rights to discretionary distributions from the trusts are limited, okay? This kind of clause prevents what we'll call the, I'm just naming it for this episode, the Carl clause, where someone slides into the picture with no legal ties, but full access to the lifestyle that you've created, okay? You can also appoint an independent trustee. So it's not your kids playing referee on whether your spouse is single enough to get that trust money, okay? Another way we can do this, and way less exciting than the Carl clause, but possibly equally important, is Roth conversions. If you have significant pre-tax retirement accounts, many folks do, consider converting some of that to Roth IRAs. You pay taxes now, your heirs get tax-free withdrawals later. Okay. This is especially useful if your spouse and kids are in different tax brackets. I'm going to do a whole different video on just Roth conversions, but let's just keep this in mind when we're doing this type of planning. And another one here, step up in basis planning. We've talked about this before, but assets receive a step up in basis when you die. Okay. But if everything passes to your spouse and then they live 20 more years, your kids might lose out on some significant capital gain savings. So sometimes it's smarter to distribute assets earlier or hold them in a trust, okay? And then lifetime giving. Use the yearly exemption per person annual exclusion to give to your children or grandchildren now, especially useful in blended families to keep the perceived, we'll call it fairness, intact, right? So let's zoom in on what keeps these families together, and then we'll wrap it up here, and that is communication. If your plan is, I'll leave it to my spouse and they'll figure it out, you're building a legacy on, we'll call it building a legacy on sand. And that's back to the opening quote. Unexpressed expectations are premeditated resentments. You need to have the talk. We need to have it with our spouse, about our goals and expectations, with your kids, about your intentions, especially, by the way, and I know this is uncomfortable, even if it's not equal, okay? Use your advisor. The advisor can help talk about how to structure the plan for emotional and financial clarity. And folks, I know this is weird. It's uncomfortable for most of you. I totally get it. Use your advisor to help. During your next review or strategy meeting with that financial advisor, ask them to invite your adult children. Good advisors can handle this for you in a way that isn't awkward. And I'll tell you this personally, I do this several times a month, and I have yet in over 20 years to have it turn into a negative outcome, we'll call it, okay? And remember this phrase, and I try to remember this when I'm meeting with especially adult children. Fair does not always mean equal, and equal does not always mean fair. So that line has unlocked, I'll call it breakthroughs in more planning meetings than I can count. So the question is, what do we do next, right? And let's wrap this up with a quick checklist and get you on your way. If you are part of a blended family or love someone who is or know someone who is, have them start here. We're going to review the current will and the trust. We would update all beneficiary designations on all accounts. We would clarify exactly what happens to sentimental items, right? And schedule a family conversation and use your advisor, okay? Meet with your financial planner and estate attorney together. That could be with the spouse, with the kids, or you could actually set it up where the advisor is meeting with the estate planning attorney. We do run those meetings too. And run projections for gifting, Roth conversions, and trust structuring, okay? And then the bonus here I'd say on the checklist is let's make sure Carl doesn't get all of your money, okay? Blended families are complicated, but the estate plan does not have to be. So if this episode struck a chord, share it with someone you care about. And if you're ready to start the planning conversation and you haven't yet, or you need an update, reach out to our team, visit our website. We have a lot of resources on there about this stuff. And make sure we subscribe, rate, review this show, the YouTube channel if you can, and it will help more families build a legacy of clarity and not confusion, because I'm going to end it with this quote: wealth without wisdom is wasted. Think about that. Wealth without the wisdom is wasted. And literally, it could be wasted if the estate plan is not taken care of properly. All right? Make it a great day.
Thank you for listening to the Great Wealth Transfer Podcast. If this podcast resonates with you, reach out to SixPoint Financial Partners at 585-485-6048 or email dpulcini@sixpointfp.com.
Content here is for illustrative purposes and general information only. It is not legal, tax, or individualized financial advice, nor is it a recommendation to buy, sell, or hold any specific security or engage in any specific trading strategy. All investing involves risk, including loss of principal. Results will vary. Past performance is no indication of future results or success. Market conditions change continuously. Information here is provided in part by third-party sources. These sources are generally deemed to be reliable. However, neither SixPoint Financial Partners, Private Client Services, nor RFG Advisory guarantee the accuracy of third-party sources. The views expressed here are those of SixPoint Financial Partners. They do not necessarily represent those of Private Client Services, RFG Advisory, their employees, or their clients. This commentary should not be regarded as a description of advisory services provided by SixPoint Financial Partners or RFG Advisory, or performance returns of any client. The views reflected in the commentary are subject to change at any time without notice. Securities offered by registered representatives through Private Client Services. Member FINRA SIPC. Advisory services offered by investment advisory representatives of RFG Advisory LLC, RFG Advisory, or RFG. A registered investment advisor. Private Client Services, SixPoint Financial Partners, and RFG Advisory are unaffiliated entities. Advisory services are only offered to clients or prospective clients where RFG Advisory and its representatives are properly licensed or exempt from licensure. No advisory services may be rendered by RFG Advisory unless a client agreement is in place.